Thank you. Please be seated. Good morning, everyone. We're here in State of Washington versus Timothy Burke, 23-1-1384-34. And I appreciate there's a lot of people that are here today, both on Zoom and physically in the courtroom. I want to make sure that there's enough room for everyone. Is everyone able to I want to make sure there's no one out in the hallways. Is everyone that wants to come in able to come in? All right, I'm getting thumbs up that everyone is present. I also want to check in before I hear from the attorneys that people on Zoom can hear me okay. Could someone let me know? Anyone on Zoom, if you could just unmute and let me know if you can hear. All right. Oh, thank you. I appreciate oh, there's a hand. I'm assuming that was a positive. But I
We
don't
can
know.
hear you, Your Honor.
Oh, perfect. Thank you. I appreciate that. For the people on Zoom, sometimes the microphones that are in the courtroom, if the attorneys or presenters that might be speaking today aren't speaking right into the microphone, it might be difficult for people on Zoom to hear. If that happens, I'm going to try to watch that, but obviously I'm not watching on Zoom. So if someone detects that they're all of a sudden not able to hear, I just want someone to put up a hand on Zoom, or you can turn on your camera if you're comfortable to do that and just wave your hand. That'll alert me to the fact there's a problem, and then we'll fix it. I'll make sure the person is speaking better into the microphone. We want to make sure everyone on Zoom can hear everything. And so just notify me in any way, either by putting up an electronic hand or unmuting and saying we can't hear. All those are acceptable to the court, okay? All right, Mr. Thunheim, you and Ms. McMullen, if you'd like to put your appearances on the record, then I'll hear from Ms. Norden.
Yes, good morning, Your Honor. John Thunheim, prosecuting attorney for the state.
Good morning, Your Honor. Elizabeth McMullen on behalf of the state.
Good morning to you both. And then you have your detective present with you as well.
Yes, Your Honor.
All right, good morning. Ms. Norden.
Good morning, Your Honor. Jenna Norden on behalf of Mr. Burke, who is present to my left. I would note, of course, that Mr. Cabrera is not present due to an unexpected circumstance. He is not available today. I did have an opportunity to speak to Mr. Burke about that dynamic. We are prepared to go forward today.
All right, I appreciate that. And then your client is not in any restraints for today's hearing?
That is correct, Your Honor.
All right, thank you. So good morning to you both. My understanding is there might be representatives from the media that wanted to be able to report on the sentencing today. Welcome to any members of the media that are present to do that. If there's anyone that wants to, for example, do photographs or video recording, there has to be permission from the court. And so if there's any requests to capture any audio or video from today's hearing, I would like those members of the media to let me know that so I can hear your request. I would hear your request and then I'd check in with both attorney teams and then make a decision about your request. Are there any members of the media that are present in the courtroom physically that wanted to make that request of the court? And I'm not seeing any. On Zoom, are there any representatives from the media that are present that wanted to audio or video record any portion of today's hearing? And there's no indication. All right. This sentencing hearing, there's a few things I just want to say before we get started. The court had set today's hearing on June 12th. The parties had conferred after the jury had returned their verdict. That verdict was received by the court and accepted by the court on June 9th of 2026. People that were present at that time might recall that the attorney teams wanted to try to come up with a date that would work from their perspectives. And the court had just informed everyone that Mr. Burke had a right to be sentenced within 40 court days of the verdict being received and accepted by the court. And so if there was any difficulty finding a date, I wanted the parties to immediately get that before the court so the court could make a decision. The attorney teams did exactly what I anticipated they would do, and they put their schedules together, asked the court to set today's hearing today, July 2nd at 9 a.m. The parties indicated they would have all their briefing filed by June 29th. That I did get a primary sentencing memorandum from both the defense trial team and the prosecution trial team. And then late in the day yesterday, the state had filed an additional memorandum, really responsive to some of the things that were brought up in the defense pleading. Ms. Norton, I just wanted to make sure that you had enough time to review that additional pleading and that you're ready to proceed today.
I did have enough time to review that additional pleading, Your Honor. The defense is prepared to go forward today.
Thank you. So just then to give a little bit of a recap, even though I know a lot of people are here because they've been very interested in this case for a long period of time. But this case started with the jury trial process May 4th. And then the case proceeded until the jury returned their verdicts on June 9th of 2026. The court had accepted those verdict forms. The court polled each of the jurors about those verdicts, and the verdicts were unanimous. The purpose of a sentencing hearing is really an opportunity to figure out what is the appropriate legal consequence for when someone violates the law. And that type of a hearing can take into account many different factors. Obviously, the more severe the crime, the more often times there'll be high levels of emotion, high levels of people that might have very strong feelings. And I appreciate that. And I appreciate all throughout the trial. This was a trial that was very well attended. People that were interested, that were here in the courtroom. I'm also aware people watched because the entire trial was on court TV. There have been a couple different media orders that covered how court TV was allowed to live stream the trial. But I was, and I said this during the trial as well, I was very impressed by how people were able to be here and be respectful. And it was clear to me that people really believed in the court process. And that came through. I do just want to let people know again that if things come up during this hearing that people feel that they can't maintain a composure, if they get where they're upset and they just need to take a minute, it is 100% okay with me for you to take a moment, step out of the courtroom, regain composure, come back in. There is absolutely nothing wrong with that. And I just want people to know they have the ability to do that, and that will be supported by the court. Obviously, the people that are on Zoom, they have the ability to do that because they don't have to have their cameras on unless they want to. I would prefer, unless someone on Zoom is going to make a statement, which would be part of the one of the attorney teams would let me know that. Everyone should stay muted unless there's a problem that they can't hear. And then I want people to let me know that as soon as that happens so we can fix that problem. And so today's hearing, I anticipate the way this will go procedurally is the state will make a recommendation. The state will let me know if there are people that want to address the court. There have been a number of letters, and I had a chance to review those. Those 5 letters that were submitted. Um, those are things that are now in the court file. And so the courts had a chance to read them a number of times. But people might want to speak in court. And so I see there's a number of victim advocates that I recognize that I know. And so I will check in with everyone because I want people who want the opportunity to address the court at sentencing to be able to have that opportunity. No one needs to feel rushed or stressed. This is a process that I know the court process takes a long time to get to this point. And so today is a day that the court, at the end of the hearing, and I haven't got through how that will work yet, but the court will pronounce a sentence. To me, that is an opportunity to provide closure, really for everyone involved in the case from a legal standpoint. And so just make sure that people that want to address the court speak to an advocate, and then I'll hear from everyone that wants to be heard. Then I'm going to switch and I'm going to hear from Ms. Norden. She'll make the defense presentation. There might be some additional material, defense filed briefing. I understand what their position is. And then Mr. Burke has an opportunity, and it's called the right of allocution. The right of allocution really is an opportunity for a defendant to make a statement to the court. Sometimes it can be a statement trying to explain things. Sometimes it can be a statement apologizing. It can be many different things, but it's an opportunity of a defendant to say anything they want. And that's a really important part of a sentencing hearing. Just so everyone knows, Mr. Burke does not have to make a statement. And the court would not use that against him in any way if he chose not to make a statement. But I will check in with him because if he does want to make a statement, I'll hear from him. At that point, then the court may or may not take a break depending on the time. And if some issue comes up that I feel the need to take a look at the materials, obviously I brought all of my notebooks from the trial in, but if something comes up that I don't anticipate, I might need to step off the bench for a moment. Otherwise, it's very possible the court could go right into pronouncing a sentence. I will do that. I will be as clear as I can to everyone about why the court is imposing a particular sentence, what that sentence is. At that point, I check in with both attorney teams to see if there's any clarifications that they have. They will then work on preparing a legal document called a judgment and sentence. The judgment and sentence, the purpose of it is to capture every aspect of the judgment. It's a long document. It also has what's called a warrant of commitment, which means that the defendant would be then committed to the Department of Corrections. There's a fingerprinting process that occurs. It takes some time. The reason I'm giving you all this information is my experience has been sometimes it's helpful for people to know that. Sometimes people want to be present for the entire hearing, but sometimes people don't want to be present for that portion because it can take some time. And so I want you to know what happens. Once the judgment and sentence is prepared, I check in with both teams to see if they are in agreement as to the form of the order. If there's something they're disagreeing about, then I would make a decision about whatever that was. Then I would review it. If it's appropriate, the court would sign it. And then the Department of corrections officers that are here would then, at that point, have Mr. Burke leave, and then that would conclude the hearing. So that's just an overview of everything that I anticipate happening, just so people are aware. Mr. Thunheim, do you have any opening comments about process or procedure before I get to your recommendation?
Only that I am aware of at least two family members that wish to speak. We've not received any notification from anybody on Zoom.
I'm sorry, Judge, but we cannot hear Mr. Thunheim on Zoom.
So the microphone, it might be easier to come up to the lectern or be seated. And I'm okay with you being seated. When it's at council table, I think it's easier, but pull the microphone close because I want to make sure people can hear you. There was someone that put their hand up there. They were titled Glorious Day and they had their hand up. And so I can check in with people on Zoom. It might be that what might make sense is we could try to take a mid-morning break after the people in the courtroom have been heard, and that might give an opportunity for the advocates to be able to inquire of the people on Zoom to see whether anyone does want to address the court.
Certainly acceptable to us, Your Honor.
All right. Ms. Norton, do you have any questions or issues regarding the process and procedure the court outlined?
I do not, Your Honor.
All right. All right. Mr. Thunheim, whenever you're ready.
Your Honor, I'm prepared to make just a few brief comments about this particular case, but given the nature of the sentencing structure that's before the court, I think today I'm not going to engage in any type of lengthy argument because really the state's position is that the sentence for this particular case, for the crimes for which the defendant has been convicted of, leave the court with very little, if no discretion in terms of the incarceration part of the sentence and perhaps not controverted discretion, if you will, with regard to other conditions that might be asked for by the state. But that being said, I just want to start off with some comments with respect to defense's assertion through what was presented as a legal objection to a life without parole sentence in this case based on a constitutionality argument. Before I actually go to address the constitutionality part of it, I just want to make some comments for the court in terms of observations from the trial that I think the court can consider in just looking at and again, tailoring a sentence that's appropriate in this particular case. We heard a significant amount of evidence regarding mental illness, and the state's expert in this case actually conceded that there has been a longstanding mental illness on the part of Mr. Burke. But I think also noteworthy is the fact that he has managed that successfully for most of his life, at least the documented portions of his life with regard to that mental illness. And in this case, there was, the defense theory about all of the extra factors that went into play here that led up to the commission of the crime. But that being said, at no point, even following the crime, or even leading up to the trial, or even during evaluation interviews by the experts, has Mr. Burke ever expressed one single bit of remorse for these two crimes. And in fact, in at least one of those interviews, appeared to continue with a sense of justification. And I would suggest to the court that really the motive around these crimes was not necessarily fear, as was being talked about from the defense theory of the case, if you will, and particularly the defense expert, this idea or need of self-defense and that these crimes were committed out of a sense of fear. I would suggest to the court that the evidence is also compelling that really what was happening here is a sense of rage or revenge. Because much of the evidence leading up to the crime was about the defendant having believed that Davido had already done something to his daughter. And the court will recall that I focused at with some intentionality during my closing argument to the jury around that statement where he related to the expert that he planned from the moment he walked into the house to either call police or kill him. And a big factor in terms of the premeditation argument, of course. But I also think when you look at that statement in the context of the entirety of the evidence, believing that his daughter may in fact be in the house in a body bag, quote unquote, that harm had already been inflicted, that this was a crime committed from a place and out of a sense of revenge, or perhaps his subjective notion of justice. Almost this sense that he was entitled or justified to do that. That I think is a factor, or at least a consideration in looking at whether the court would even consider the fact that his mental illness was somehow a mitigating circumstance in this case, because it seems very clear from the evidence of the case that he had the capability of managing this. He understood what was going on. He had some self-awareness of his sense of paranoia and stress. He actually talked about that in one of the interviews to the expert, and yet made that decision anyway to go and to commit the crimes that he ultimately committed. With regard more specifically to the constitutionality objection, I want to point out very clearly for the record that that would be defense's burden to make, to prove somehow that the statute in this case as applied, and not necessarily just this case, because I think the court would have to consider whether we're talking about some kind of categorical exemption here on a constitutional basis to what has been clearly, very, very clearly mandated by the legislature to be the appropriate sentence for a case of aggravated first-degree murder, what we're dealing with here. And in this case, there has been no presentation by the defense or evidence by the defense that this statute is somehow
Let me interrupt,
unconstitutional.
and I'm really sorry. There was someone that unmuted on Zoom, and that might have been an accident. I don't know. But if they had a question or they couldn't hear, I want to know that. It was, I believe, Lizzie W. Lizzie, did you have a question? I think it was an error as far as I can tell. Mr. Thunheim, you may continue.
Okay. And so there's no presentation here of any evidence or argument presented by defense, which would somehow support this idea that the aggravated murder statute, as it's being applied in this case in particular, or categorically for defendants who come before the court with a diagnosed mental illness, in any way is unconstitutional in the sense that of a punishment that is unduly cruel or unusual, as that's outlined in both our state and federal constitution. I'm not going to spend a lot more time arguing that, but I'm certainly open to answering questions for the court or expanding further on the argument as need be, or perhaps offering rebuttal once defense has presented their argument in that regard. I just want to note, however, that the case law seems to be very clear that there are 4 factors essentially the court looks at. All of those factors in the state's view lend itself actually to a finding of constitutionality. There's no precedent or other evidence that the state's aware of at either the state or federal level for a finding of cruel and unusual punishment as it might relate to this case or similar cases of this nature. There's no statutory
Mr.
authority.
Thunheim, I'm really sorry. I apologize. Lizzie W., I need you to be muted unless you have some concern that you can't hear. You keep coming on, you're unmuting.
I'm done with everything.
Lizzie W., do you have a question for the court? Lizzie W., please unmute for a moment. Are you having an issue, ma'am? Lizzie W. Lizzie W., I'm going to have to ask you to exit the Zoom room if you cannot stay muted. You keep unmuting and you're interrupting what's going on in court, which is very serious. If there's an issue, I want to be able to hear from you, but it looks like you just continuously are muting and unmuting, and we're getting background noise in the courtroom. If you have a question or there's some confusion, please unmute and ask me now. Otherwise, if it continues, I will have to remove you from the Zoom lobby. Lizzie W., do you have a question for the court? Mr. Tunheim, I don't lightly take, it's really unusual that this happens where it's happening repeatedly. And so if it continues to happen, my thought is to remove Lizzie W. from the Zoom lobby. I won't do that unless it continues to happen. But does the state have any concern? Do you know who Lizzie W. is?
I don't have any information to help the court. I'm at this point not requesting the court take any action like that unless it becomes more pervasive.
Okay. Ms. Norden, do you have any records you want to make? Again, it's one of the complications sometimes when we have a remote hybrid hearing where we have people attending in person and people attending by Zoom. But it looks like now, at least for the past minute, Lizzie W. has stayed muted. But I am concerned if it continues. I have limited options.
I don't have any information for the court. My hope is it ceases being an issue and we're able to move forward.
All right. Thank you. I appreciate that. All right. Again, for everyone on Zoom, I will check in at some point with everyone on Zoom, but it's important not to have interruptions during the hearing. Just like if you were here in person, we wouldn't have people speak out when the attorneys are making their presentation. So please do not do that. Only if there's some problem that you can't hear the courtroom, then of course, please tell me. But otherwise, please do not unmute. All right, go ahead.
Returning then, Your Honor, just to briefly discuss.
And I'm sorry, just to complete the record, I have not removed Lizzie W., but it looks like Lizzie W. may have fallen off Zoom at this point. And so if it continues to happen, I'll check back in with the attorneys, but hopefully it won't be an issue.
Okay, thank you, Your Honor. Just returning briefly to the four factors I was just discussing with the court. The first is what is the nature of the offense? And of course, in this case, we are dealing with the most serious offense under Washington law. In fact, I think the SRA actually categorizes it as a most serious offense. The legislative purpose behind the statute, it's very clear. The legislature has spoken in its purpose, both in the Sentencing Reform Act and in the aggravated murder statute, that this is intended to be the most serious punishment imposed for the most serious offense. The punishment of the defendant would have received in other jurisdictions. It's a little bit vague in terms of what that means. We know that it would be consistent across the state of Washington because this is a mandated sentence for this type of offense. I've not done investigation or cited any specific cases or statutes, but I think I could say under general understanding that in many states, if not most states, a sentence of this nature would not be inconsistent with the sentence imposed by the legislature in our state. And then finally, the punishment meted out for other offenses in the same jurisdiction, which I just addressed. And so under those four factors, there's really no basis for any kind of finding of unconstitutionality based on this sentence being cruel or unusual. So for that reason, we are simply asking the court to follow the statute that requires a sentence in this case for counts 1 and counts 3 of life imprisonment without the possibility of parole. And I want to be clear, just for the record, also that in the aggravated murder statute, which is RCW 1095-030, paragraph 1, there is a very, very clear statement, I would suggest to the court, of an intent on the part of the legislature that is a mandatory sentence. It says in part, a person sentenced to life without life imprisonment under this section shall not have that sentence suspended, deferred, or commuted by any judicial officer, and the indeterminate sentence review board or its successor may not parole such prisoner nor reduce the period of confinement in any manner whatsoever, including but not limited to any sort of good time calculation. So there's very clear legislative intent stated in this statute that this is a purposeful and intended consequence for this type of most serious offense. I would also suggest to the court that the arguments made by defense really are more policy-based arguments that frankly belong in the legislature. That is their function. But in terms of asking the court to in some way deviate from law based on this constitutional analysis, very brief constitutional analysis, I would suggest does not meet their burden in that regard. So therefore, our recommendation, given the circumstances of this case, the court heard all the evidence of the case, understands the nature of the crimes and so forth, and based on the comments that I've made, we're making the following sentence recommendation. For count 1, life in prison without the possibility of parole. And I would note that we are conceding that count 2 merges to count 1. That was actually knowing and intentional in terms of the charging. It was charged the way that it was as a way to give the jury the ability to very clearly relay its deliberation findings to the court. But in this case, the jury did find that there was premeditated murder and that there was an aggravating circumstance. And so we concede that count 2 merges. So we're not asking the court to impose any sentence whatsoever under count 2, but simply merge that with count 1. As to count 3, we're recommending a sentence of life in prison without the possibility of parole consecutive to the sentence imposed in count 1, which we submit to the court is also a requirement of the Sentencing Reform Act, as both of these counts would be considered serious violent offenses. And again, conceding that count 4 should merge with count 3 in regard to sentencing purposes. As to the issue of community custody, murder in the first degree is legally classified or could be legally classified as a serious violent offense. Generally, there would be 36 months of community custody. That it seems to be, and perhaps even is intended to be, moot on the part of the sentencing structure in Washington, given the incarceration sentence. But we would ask the court to note that if for some reason there were ever a consideration of release by the defendant, for any reason, that the court authorize and order community custody for a period of 36 months with the conditions that we have outlined in our memorandum, which I think are consistent essentially with statutorily required conditions. We're asking the court today to reserve an order for restitution until we can have a final restitution amount to propose to the court. We are certainly willing to work with defense to see if agreement can be reached on that in that regard, but we would ask for the ability to reserve that issue for future order. But we are asking the court to order restitution and only reserve in terms of what the amount is. As a condition, obviously, the defendant should not be allowed to own, possess, or have under his control any firearm at any time in the future. And we are asking that the firearm that was used in this particular case be forfeited because of the nature of its use in this particular crime. Again, from a practical standpoint, that firearm is in evidence with the court. It probably will be in evidence for a very long time and may be retained by the sheriff's office as part of its evidence program for even longer time. But that being said, we're asking the court to simply enter the order that forfeits it to have a legal conclusion on that. We're also asking, for purposes of conditions of this sentence imposed on the defendant, that he have no contact with any family member of Davido or of Karen. We're also asking for no contact with any witness who testified on behalf of the state or during the state's case in chief. Prior to coming on the record, we had a brief conversation with defense, and I think have agreed to exclude from that order absent independent requests, which we don't have at this point. The defendant's daughter who testified as part of the defense case, nor the defense expert. Again, not knowing if there's contact desired there or not, we're not seeking a condition of no contact with those two individuals at this time. I think that covers the substance of my recommendation. I would be happy to answer any questions of the court at this time or engage in further argument later if the court desires such.
I don't have any questions for you right now. I appreciated the pleadings that were filed. They explained the state's position, I thought, very well. And so I don't have any questions currently for you. You said you thought two people in the courtroom, and my thought is I could hear from those two people. It would give an opportunity for people to reach out if they also wanted to be able to address the court. They could let the victim advocates know. Maybe right after we hear from the two people who identify themselves, we take a short break. So that way, if there is anyone else that wants to address the court, they have time to do that. Is that acceptable?
Absolutely.
All right. Who would you like the court to hear from?
First, Your Honor, I think we'd ask the court to hear from Justice Dutton.
All right. Good morning. I want you, please take your time. Please, thank you for coming today. I know you were here throughout, really, I think all the hearings, but definitely all of trial. I just want you to identify yourself for the record. If you can make sure the microphone's close, that way the people on Zoom will be able to hear you as well. And then anything you want to tell me, this is your opportunity, and I will listen to anything that you tell me.
Thank you, Your Honor. So I'm the eldest son of Karen Davido. They named me Justice. Present at the courthouse today was my eldest son. His name is Jack. He's about 14 months old. As Your Honor is aware, Mr. Burke has been incarcerated for over 30 months, and so it's about twice as old as my son has been alive. When I think about my parents passing, what brings me the most sorrow is the knowledge that they would have been so happy. It would have brought them the most joy in the world to be grandparents. I was never able to share that knowledge with them, nor as my younger brother. So I just thought I'd take a moment and maybe share some moments that I know that they would have cherished and that I know my son would have cherished. When my son was born, my parents weren't there to be able to feel his little hands grasp around their fingers. They weren't able to see his wobbly first steps or the proud ones that he took when he walked into the courthouse today. My mom is never going to be able to read highlight books and do the hidden pictures with him. My father will never read books about great adventures or surviving alone in the wilderness. There's not going to be a school play where my son can look out into the audience and see his proud grandparents, maybe. He will never have the opportunity to wonder how that awful tasting herbal remedy that his grandmother put out on the counter somehow was exactly what he needed to kick a cold. He will never walk into the hardware store with his grandfather, stroll the aisles looking for the last part that they need to fix a sink. He won't smell the lumber or the sawdust as they build the coolest play structures in the world in the backyard. When he graduates, he won't look out and see his grandparents holding hands and realize that his grandfather actually does own more than one style of shirt. So these are the moments that I know would have brought them the most joy in the world. Quite frankly, I think they're some of the most precious moments that you can have in a life. So during testimony, we heard from Mr. Burke's daughter about the strained relations that they had. It's my sincere hope in the future that they're able to mend that relationship and that one day Mr. Burke is able to come to learn that he will be a grandfather and understand that the moments that he took away from my parents and the moments that he took away from our son, when he took those away from himself and from his grandchildren. Thank you.
Thank you. I really appreciate you being here and sharing. Thank you.
Next, Your Honor, we would ask the court to hear from Pauline Dutton.
Good morning. I also appreciate that you have been at every hearing that I've presided over, and I think every day of the trial I saw you here, and so I appreciate you're here. This is your chance to tell me anything you want to tell me. And again, I want to emphasize, I want people to feel free to take their time. There is no need to rush. It has taken a long time to get to this point, and I want to hear everything you want to tell me.
Thank you. I've written stuff out because I can get really nervous and I can go completely blank. My statement is a little bit lengthier. First of all, I want to thank you for the opportunity to share today. It's an honor and a privilege to be able to share how I felt during this whole entire process, as well as portions of how I know the community felt and my whole entire family and Davido's sisters. My name is Pauline Dutton. I am Karen's younger sister by 9 years. I'm the middle daughter in our family. I have a younger sister named Catherine, who is disabled and has not been able to attend. And I know it's been a little frustrating for her because not everything has been on court TV, like the evidence and such, but at least she had that. I want to first state how the unfolding of Tim's crimes has affected me and my family over the last 2.5 years. And then I'm going to speak about the impact of the loss of Karen and Davido and how that's had an impact on my family and I. I'm going to start off about the worst day that I've ever had in my whole entire life, which was Monday, November 13th, 2024, when I received a phone call from Karen's longtime friend and office manager, Kathy Pratt, who advised me that Karen was missing that morning. My sister showed up for work every morning at 5 a.m. She was a very dedicated and passionate person about her job and her role as a healer. So we knew something wasn't right, and I tried to keep it together. I didn't want to panic or go into fear straight away. But we did not know what was happening. And I contacted Justice, my oldest nephew, and immediately him and his partner got in the car and started driving to Olympia. I, unfortunately, was stuck in Portland, Oregon, taking care of my 91-year-old mother, who I am her caretaker. I couldn't just drop the ball. I felt like I was in a position of complete and utter lack of control. I got to look at my notes. Sorry, I apologize.
You take the time that you need. There's no need to say you're sorry. You're fine.
I'm shaking so badly.
And Miss Dunn, let me just tell you too, if you need a break at some point, we can take a break. And so it's totally fine, okay? I just don't want you to feel that you have to rush or hurry.
Your Honor. This is highly unusual. My sister never missed work or even took time off. She had a strong work ethic and a deep passion for her patients. I honestly don't even know if she took more than a day off for the birth of her sons. I mean, that is how dedicated my sister was. I was really caught off guard and try not to panic, as I had previously said. I called my nephew, yes, blah, blah, blah. After we learned about law enforcement entering the home and finding out that they weren't present, and that there was significant blood, I began to panic. My mind raced through all sorts of scenarios of what could have happened. A detective called me straight away and asked to speak to me. She wanted to know what my gut feeling was on what had happened. And I had no idea, but a voice inside my head, which I do believe is my sister's, told me to tell them, go to the Stedman property. You will find your answers there. My sister has been with me this whole entire time. Thank you. I knew something had to do with that. I just knew. My mother and I felt completely powerless and out of control. I couldn't just get up and leave. I already said this part, sorry. I wanted to be up here to help my nephews and support them and help look for my sister and her husband and to provide support. For 3 agonizing, let me just say that again, agonizing 3 weeks, we waited and suffered as a family and community. Thanksgiving holiday had been planned for my sister and her husband to come and be with us. The waiting was complete hell on earth. We were all praying somehow that they would still be alive. We didn't have all the information. The detectives gave us what they could. But we were advised by law enforcement that the amount of blood in the home was most likely not survivable. Our hearts sank in despair, and I had to continue to keep showing up every single day and take care of my mother. I did not have time to have a pity party, to grieve, to show my pain. I had to show up. I needed to stay strong. The amount of strength I had to take in order to mask and get through that was significant. My mother has suffered several strokes. I did not need her having another stroke. It was very difficult for me to decide how much to shield from her. Yes, she's a grown woman, but she's also very fragile. She's in a fragile state. People who have had strokes cannot comprehend emotions the way others can. I took a lot of grief for that. People were telling me what I should be and shouldn't be doing. That's a lot of weight to put on a person. It was a very tough balancing act, but I had to push through. My older sister, Karen, gave me so much strength during this time. My mother tore my heart open when she kept asking about Thanksgiving and wondering if they were coming. We still didn't know what had happened to them. It broke my heart to see my mother cry when I had to tell her that her firstborn daughter was missing and most likely dead, along with Davido, who was a big part of our family. During that time, I was barely eating or sleeping. I was inundated with phone calls, texts, speaking to reporters on top of taking care of my mother. I look back and think of the incredible strength that it took to get through that. I don't know that anybody else has had to put up with that much pressure and strain. Like, I just can't not a normal person. Obviously, there's people out there who have done great things. And I'm not saying that I'm great, but I'm saying that that was really tough. And I don't think most people have to endure that kind of thing in their lifetime. We got to spend Thanksgiving alone. That was super fun. Me and my mom. It's really hard to put on a holiday by yourself. You know, I got to show up. I got to pretend everything's fine. I got to produce a holiday on my own. I was suffering. I was depressed. I was numb. I was sick. In early December, we received the dreaded phone call that their bodies had been found, and my heart sank. It just sank so deep. Part of me was relieved. Finally, we had that weight lifted from us. We could start to let ourselves grieve. I remember being very angry at learning that their bodies had been dumped in the woods out in the open. I thought that was very disgraceful. My sister and her husband did not deserve that. But then I heard a voice in my head, and it was my sister's voice. And she said, "No, it's a blessing." And I kid you not, that's exactly how my sister was about everything. She found the blessing in everything. I feel like her and I were born polar opposites. I was born with the negative Nelly in my head, and she was always positive. She mentored me and taught me so much. But when I heard that, again, she kept showing up for me in my head, giving me the strength to get through this. It was a blessing. It's exactly the kind of thing she would have said if she was here today. She would take the perspective, the higher road, the positive. She always tried to find the blessing. So I did find the blessing in that, you know. I talked to so many people in this community, and so many people are suffering from having a missing person, you know, and not having the answers. And that is, I know that struggle is heavy and hurts, and people just have to carry on. So I do feel blessed that they were found so that we could stop worrying. And I know that prayers from the community were had been being said, and those prayers came true. So I appreciate all the prayers from everyone. Okay, one moment. The 2.5 years that we've waited for this trial and the multiple reschedulings has been beyond frustrating for all of us. I know it's the process. We get that. As a family, we struggle staying positive. It's hard to stay positive for 2.5 years. You have expectations that things are moving forward. It was completely maddening for Tim to have all the control and for us to be stuck waiting with zero control. I felt like he manipulated the system during this time. I felt like games were being played so he could see what he could get away with. I don't know, but that's how I felt. All of our lives were put on hold. We couldn't plan anything with certainty. I know Davido's family members, his sisters, made multiple reservations and had to cancel so many times because we had to keep changing trial dates. So they lost out on a lot of money. And that's really unfortunate. I didn't bother to make reservations because I could tell this thing was going to drag out. When we finally got word that the trial was going to actually happen, I was going to actually, I'm sorry, when I finally found out that the trial was going to happen, I feel like we had just a couple days to try to make reservations for my mom and I. And finding a handicap accessible room is a lot harder than one would think. The handicap accessibility in this country is close to non-existent, and has a lot to be desired. The driving back and forth to Portland, Oregon on the weekends so that I could have a day off and see my family and my pets, that took a toll on me. I know it took a toll physically and mentally on my mother and I. This was not easy. I had to pack up all of her stuff, all of my stuff, and come up here and set everything up. And I'm talking bringing arm poles for the beds so that I could get her in and out of bed. I have been waiting to have a surgery done on my arm, but I haven't had time to do that because we've been waiting for this trial. And so I haven't had the medical treatment I've needed to have. But anyhow, I had to keep showing up. I wanted to be here to support my nephews. I wanted to see this thing through the end. And it did take a toll physically and mentally on my mother and I. I mean, we could have watched on court TV, but a lot of things were not shown on there. And so I am glad that I had the opportunity to be here. A lot of the evidence was not shown. I struggled with wanting to see what he had done to my family members. It was my one opportunity, and I struggled really hard with that. I am never gonna get the image of seeing my brother-in-law's skull cap on screen. I never needed to see that, but it's something I had to do for myself. Those 2 days where we were waiting and trying to figure out what 9 pictures were gonna be shown and which ones weren't, blah, 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 and how, it took at least 45 minutes one morning to go over that. I was beyond frustrated because I got myself really worked up trying to debate whether I was going to look at those pictures or I wasn't. And, it turns out they only showed 2 of those photographs and they weren't that bad. And so I let my guard down. And then the next day was the autopsy photos. And being naive as I am, I was completely caught off guard because I thought an external autopsy was done on my sister and brother-in-law. I had no idea that one in-depth was needed. So I was very taken aback, and it broke my heart to see my youngest nephew cry and leave the room. Just ripped my heartstrings out. We sacrificed, all of our families sacrificed a lot financially and time-wise, hotels, food, gas, you name it, to be here, which is nothing. I don't care. I just want it to be out there. That was a sacrifice. But we had to sit here in this courtroom for 5 weeks and hear in detail what Tim did to our loved ones. Hearing about evidence and seeing photos that were heart-wrenching, and then we couldn't show emotions. I know I showed some emotions. I'm an empath. I can't just shut it down. That was really hard for me. That was really hard. And I know that you do this all the time and it's something that you have to see, but the struggle was real for me. There was one night that I think through the ballistic testing section that we went through where it was a very boring day. I mean, I'm sorry, but it was hot in here and I could not stay awake. So I overdid it with caffeine that day. Okay. I had my Starbucks too late in the day. I couldn't sleep that night. I proceeded to eat peanut butter M&Ms and make myself sick. And then the next morning, I was crazy. I mean, I felt emotionally hungover. And I felt like I had a brief psychotic episode in the hallway in front of people where I broke down and I said things that I felt about him. And that was embarrassing for me, but I didn't have proper sleep hygiene that night. I didn't have proper nutrition. I let this whole process get to me. But I pulled it together and I'm still here today. I was surprised to hear about different things, pieces of evidence. I would think I'm completely fine sitting back there. And then I'd hear something like, and then the black Puma socks were found near the trail. And I'm like, I know those are my sister's Puma socks. And I don't know why, but that just jabbed me. It's just shocking to hear. It's just shocking to hear. I know I'm going into a lot of detail, but this is what I went through. Let me try to pick it up here. One of the bigger things is my faith has been tested through this process. I wanted to hate him with all my heart, and there's periods of times where I did. He took two of the kindest souls on this earth away from us in such a violent and senseless manner. Davido was trying to help him, and it was shocking and saddening for me to hear that he felt like Davido was a bad person and that he was even capable of hurting him or his daughter. I continued to pray for these 2.5 years, and I finally had a shift in my perspective. And I came to a place of forgiveness because that is what I've been called to do. God has the ultimate say. I am freeing my heart and my soul through this act. I am not giving Tim a free pass for what he has done. As a child of God, it is not my job to punish, spread hate, or deny forgiveness. When I do these acts, I am playing God, and I am not God, and I know that. I don't think that I'm better than anyone either by saying these truths. I know this topic is very uncomfortable for a lot of people. I've taken a lot of pushback for it. But I want people to know, if they didn't already know, that Karen and Davido were people of faith, of deep faith. And it showed in their actions on a daily basis and how they showed up in their community, with their family, their neighbors, and their friends. I'm going to continue to stand tall and behind my words and my convictions. When this tragedy unfolded, I became fearful and I became scared in my own home. When they were missing people and I didn't know what had happened, I started double checking my locks. I was watching my back, going to the grocery store. I didn't know what I should be fearful of. I didn't know what happened. I didn't know who to trust. I pulled back from helping out in my community, and I became hardened. And it's easy to become hardened in this world that we live in, especially today. Everything's moving faster. But in honor of Karen and Davido, I'm going to continue to reach out my hand and help others. I will show up for those in need. Now I'm going to talk about my sister briefly. That's a joke. Okay, my sister Karen had many roles. She was a daughter, a mother, a sister, a wife, a devoted friend to many, and a talented and gifted chiropractor. With Karen, you always felt seen and heard. She was a mentor and my best friend, and constantly my cheerleader. Her and Davido provided so much support for me with my mother. When I needed a break, they would drive down to Portland and watch my mother, even Davido, by himself for me, so I could have a day off. They never complained. Karen was generous with her time and her talents. She had many endearing qualities. She was hardworking, dependable, dedicated, humble, respectful, funny, and lighthearted. She remained curious, and she always wanted to learn and grow. She was passionate and dedicated about her practice and helping her patients. Throughout this time, I have been contacted by so many of her patients and have heard endless stories about how she has healed their children, helped them get additional care outside of her practice. She advocated for them. She went above and beyond what any chiropractor would do, in my opinion. She knew her patients. She knew their families. She knew their children. She went to their children's sporting events to watch them and cheer them on. Community was important to her. She knew all her neighbors, and she watched many of their dogs. She made treats for their dogs. She was excited to see people. She was a faithful servant of God and attended Bible study with many people in this community, and I've heard from many of them, and it really has touched me in a special way. She wasn't interested in material wealth or belongings. She actually abhorred that kind of stuff. She said on a regular basis that she was going to work until she was 90, and she was enthusiastic and serious about that. And that opportunity has been taken away from her, as well as the opportunity to get to know her grandchildren. When she met Davido and introduced us, I was skeptical, and I was very taken aback by his kindness, his politeness, and his patience. I have never met anybody like that, and I probably never will. Through his consistent actions, I came to realize that he was genuine. And at our family gatherings, he was always the first to get up, clear the table, do the dishes. He wasn't asked to do this, he just did this. When we were at their house visiting, he would always be making us food. He was a very attentive host. The Stedman rental property was a project he came up with in order to help those that needed a hand. He believed in second chances and wanted to provide people with the ability to get a leg up. He envisioned a place where people could live together in a community type setting, helping each other. He offered people discounted rent, resources, work on the property, and other opportunities. His work as a landlord presented him with many headaches. He practiced setting boundaries, providing perspective, and diplomacy with his tenants. It really saddens me that Tim saw him differently and as a threat. He was kind to everyone and also devoted to God and his family and the community. The saying, no good deed goes unpunished, has proved to be true in his case. After he was gone, the tenants had to find new homes. Some of them became squatters and didn't pay. They dumped their garbage and discarded their belongings on the property, leaving my nephew, who already had enough pain, sorrow, and grieving to go through, as well as dismantling my sister's practice. He didn't have time to grieve. He had to deal with these people who wouldn't leave the property because they were entitled. They felt sorry for themselves. That breaks my heart. It took about 8 months of harassment and abuse, verbal abuse from a certain tenant in order to get the family to finally leave the property. My nephews did not deserve that. The cleanup job on the property took at least 7 large, extra large dumpsters, and it took over several weeks of work with many family members and community members assisting. The time and resources spent were extensive, and it was hard to believe that people, knowing the circumstances our family was under, still felt so entitled and were able to be so disrespectful. Karen and Davido were unique, rare individuals who have left this world a better place just for being in it. On a positive note, I'd like to say, let's all try to follow the example they led. Love your neighbor and help others and be of service. Lastly, what I saw sitting through this trial was a person who became hyper-focused on being a victim of their own making. They got pulled down into the deep and bitter morass of self-pity, and they couldn't pull themselves out, and they took it out on my family. I want to thank everybody who has worked in any capacity on this case. I don't know if this is the appropriate time to say that, but I feel like it's my only chance. A lot of time and effort was taken to help find justice, and it is very appreciated by the family. And in closing, and this is a very unpopular opinion, but I'm going to say Timothy Burke has the opportunity to repent to a God that he may not understand. He can ask for forgiveness, and he can save his soul if that is something he desires to do. And so I'm going to witness that today as part of my faith. Thank you for your time, Your Honor.
Thank you. So what I think probably makes the most sense right now is this is a good opportunity for us to take that mid-morning break. We're back on the record in state of Washington versus Timothy Burke. And present are Mr. Burke, Miss Norden, and Mr. Thunheim and Miss McMullen and Detective Hunt. Mr. Thunheim, were there any other individuals that the state wanted the court to hear from?
During the break, Your Honor, we pulled the Zoom participants. We had no response in terms of anyone who wanted to speak further, and I'm not aware of any other persons present that want to speak.
Okay. I appreciate you doing that. And I'm just looking around the courtroom, checking Zoom as well. It doesn't look like anyone else does want to speak. I appreciate, again, everyone is here. Ms. Norden, I'll hear from you.
Thank you, Your Honor. Good morning, Your Honor. It's hard to know what to say at a sentencing hearing in a case like this where there is a great loss of life. It's abundantly clear that the deaths of Karen and Davido have greatly impacted their family, friends, and community. And there's no end date for that impact. I can tell the court that from the first time I met with Mr. Burke, that it was clear to me, and I acknowledge, of course, that I'm an attorney. I'm not a mental health professional, but in my opinion, that Mr. Burke is someone who is greatly impacted by significant mental health issues. I think that this is clearly reflected by the court record in this case. There were multiple competency evaluations. Those requests reflected very genuine held concerns of the defense. The defense had significant competency concerns, frankly, over several years that this case was pending. Those current concerns did not completely dissipate until after Mr. Burke had been taking antipsychotic medications for a time period. And it, of course, has been the defense position that Mr. Burke was impacted by mental illness to the extent of being not guilty by reason of insanity at the time that he shot Karen and Davido. Ultimately, of course, the jury rejected that defense, but it is the defense position that but for Mr. Burke's mental illness and how it specifically impacted Mr. Burke, the defense does not believe that we would be here today. And the defense is not equating mental illness with dangerousness. I think actually quite the opposite. I think that there's research that consistently shows that the majority of people with mental illnesses do not commit violent acts, and that most violent acts are not due to mental illness. I think that Mr. Burke's actions in shooting Karen and Davido and that connection to his mental health, those represent an anomaly. I agree that when I look at the law in Washington state, and I look at that law and I look at the jury verdicts that have been returned in this case, I largely agree with the state's analysis when it comes to what the law requires Your Honor to do, which is to sentence Mr. Burke to life in prison without the possibility of parole for count 1 and count 3. And I also similarly see that the law requires those sentences to be imposed concurrently. I believe that under...
Do you mean consecutively?
That is what I meant, Your Honor. Thank you. Under RCW 1095-030, that statute does not give Your Honor discretion to consider Mr. Burke's failed defenses of not guilty by reason of insanity. The defense certainly has objected to RCW 1095-030 and its sentencing memorandum on constitutional grounds. I'm not going to belabor that point, Your Honor. I would just rest on my written objection. But the defense is making an objection under the Washington state and the United States constitutions related to cruel and unusual punishment when it comes to the current law in Washington state and how it does not provide the court with any discretion in cases like Mr. Burke's, where there is an established mental illness, where it is established that that mental illness was present at the time of actions that were crimes, and a mental health defense is raised, but ultimately not successful. Your Honor, I am not objecting to the other conditions requested by the state. We have no issue with the court ordering that Mr. Burke not have contact with witnesses that were called to testify in the state's case in chief. We, of course, are happy to hear it limited in that manner because certainly Mr. Burke would object to any condition that would restrain his ability to have contact with his daughter. Similarly, we're not asking for any no contact condition related to the defense expert. Thank you, Your Honor.
Thank you. Mr. Burke, you have an opportunity to make a statement to the court. That's a opportunity that you have, that you can tell me anything you want me to hear or consider. That's your opportunity. You don't have to speak. I'm not going to hold it against you if you choose not to speak. But if you want to make a statement, this is your opportunity to tell me anything you'd like me to know. Would you like to make a statement?
Brief statement.
Yeah, go ahead. And if you could just tilt that up, just because I want people to be able to hear you, okay?
It's hard to know what to say in a situation like this. I know that I have mental health issues. According to the expert, likely brought about by several severe head injuries as a child. One time I got really nervous about cutting a tree down. I was cutting a tree down on my own. And I knew how to do it. It's very simple. But I ended up doing it backwards and the tree fell against a building. And I think that's just one example of how my brain sort of shuts off under periods of high stress. Not obviously my brain completely shutting down, but my ability to function being compromised. Also, obviously, have very different points of view with other people here on what exactly happened, who exactly Davido and Karen were. I didn't really know Karen very well. I got to know Davido very, very well. And my experience is very different from other people's. I'll just give you one example. I told him a story about how a past landlord tried to get me arrested by calling the police and lying to them. I had everything on video, so they weren't successful in doing that. And Davido offered at one point later, offered to help me kill that guy. People don't understand narcissism, let alone covert malignant narcissism. And people can be very different from what people think they're like. Ted Bundy, for example, all his coworkers and family thought he was a great guy. They couldn't believe that he was the guy who did what they did what he did. Likewise, the women that got into his vehicle thought he was a nice, charming guy. Over 100 women, I guess. But I didn't really know Karen very well. I thought I heard her talking to someone about tracking my daughter down, but it could have been a delusion. I don't know what the truth is. So all I can really say is that that I'm sorry that I did what I did, in the sense that if it was wrong, I am sorry. I do know that I was really completely out of my mind. In my normal state, I'm completely incapable of doing acts like that. I was stressed to a point that most people, I think, never experience after the death of my daughter and the arson. There's a lot more that I could say, but it's really, I think, sort of pointless. The things I did were horrendous and unthinkable. And it's hard to believe that I did them. I don't have anything else to say.
Thank you, Mr. Burke.
I don't have anything further, Your Honor. Thank you.
Thank you. Mr. Junheim, you had mentioned the possibility the state might ask for an opportunity for rebuttal. I don't have any questions for the state specifically, but did the state want to make any additional arguments?
No, Your Honor. Thank you, though.
All right, you're welcome. All right, so Mr. Burke, Ms. Norden, Mr. Thunheim, Ms. McMullen, Detective Hunt, I appreciate, and I've said this throughout, that I thought this trial, while I know it took a long time, I think it was 20 days of trial. I just am appreciative that I thought both sides did exemplary work from their perspectives, and I appreciate that. So
Can I say one more thing?
you can say one more thing.
Sorry, I just forgot. I wanted to talk about the prosecutor's expert and their evaluation of me. The prosecutor had a very short evaluation with me, and she talked about things during trial that she never discussed with me. One example is my inventions. She said that I was delusional because I thought I had a valuable invention, but she never discussed with me whether I actually thought that invention was likely to work even. She never talked to me about it at all. And there was other examples like that, and I feel like I didn't get a fair shake, basically, from that evaluation. As far as the invention goes, on my high temperature heat invention, I don't think that it's a high likelihood that it will work. It's very likely that my invention won't work. I don't have a patent. I don't have a working prototype. That's true. But she never discussed those things with me. So I never got the opportunity to say that. I have other inventions that I have thought of while here in jail. One of them is a solar invention. I do think that would be very successful. But again, I don't think having an idea that I think is really good, that I think will work, makes me delusional. You can have a good idea and think it'll work, especially if you're an engineer and have the qualifications to evaluate that invention. And especially if it's a simple invention, that doesn't make you delusional. And I think that was like her only example, really, that she could come up with of me really being delusional. Also, I don't need to say anything else.
All right. Thank you, Mr. Burke.
Thank
you. So I want to address all the people that were friends and family of Karen and Davido. What's been presented to the court is they were truly exceptional people. They were, and they've been described this way in a lot of different formats. But today, we obviously heard from Justice, and we heard from Miss Dunn, right? Yeah, thank you. But I also had letters from Catherine Pratt, and during the trial, we had heard from her husband as well. Deanna Lynch, who was a patient of Karen. Catherine Tomlinson, another sister. Linda Canizo, and Ron Rowland, who I think he had been friends with Davido for about 45 years and considered Davido and Karen to be like a brother and a sister. And there were some themes that came out, from the court hearing about them. Remarkable people who made the world a brighter place. And I'm just taking some of the things that were said by different individuals in their letters. Catherine, of course, talked about just how dedicated and committed Karen was to her practice and to her patients. And just, again, that word healer came out a lot when people talked about Karen. Davido was peacekeeper. That was sort of the word that sort of kind of resonated out. And getting to hear about them was powerful to me, and being able to hear from the people that loved and cared about them was meaningful and important. Also, I'll just say, and I reflected on this a lot throughout the trial, but it was clear to me just by how family and friends and the community in general had this outpouring of love and kindness for Karen and Davido. They were felt in the world, right? Like, they were seen by our community, and there were these people that were always willing to give and care and put their light out for the world to see, and to sort of be, I think, an example. And so that was powerful. One of the things that Deanna had put in her letter, and I think it's really touching, and I will try not to get choked up too, but I'm just going to quote from her letter. It says, "The only comfort to any of this situation is the knowledge that Karen and Davido raised two kind and generous young men. You don't become kind and generous unless you have great examples to follow. And Karen and Davido provided that guidance. Karen was incredibly proud of her sons." And if I read the rest of that paragraph, I probably will start to tear up more than I have already. There was a couple things that got shared by Catherine that I just, again, I think are noteworthy for a sentencing like this, because this sentencing is obviously going to deal with the legal consequence to Mr. Burke, but it's really about the loss that's been suffered. It's really about the loss of these two people. It's really about the fact that these two really exceptional people in our community are removed from the community. And so I want to highlight that because I think it's really important. There was a story that Catherine told that it was on her very first day at the University of Oregon, and probably family knows this, but maybe not everyone that's in attendance does. Catherine reflected, "My chemistry professor stood in front of a class of nearly 500 students, looked at me and asked, 'Karen Dutton?' And Catherine's writing, she says, 'I smiled and replied, that's my sister.' He said, 'I know. One never forgets the best.'" And again, I just think it says a lot. Again, this idea of Davido as a peacemaker, and Catherine, I thought, wrote really thoughtfully about this as well. She said, "Davido was the peacekeeper of our family. He cared for my mother with incredible love and devotion. He would drive from Olympia to Tigard to help with her daily needs, take her to appointments, and do yard work. He gave his time without ever asking for anything in return." And she talks about personally how Davido, with some of the struggles that she was going through, that he just always, the impression that I received was that he wanted to understand, he genuinely wanted to help, and he would listen and then do his best to help people. again, this theme of a light in the world, Linda, she talked about together, Davido and Karen made the world a brighter place. They were the kind of people who gave more than they took. They shared their time, their knowledge, their resources, and their love freely. They made people feel welcome, supported, and cared for. There's a point I want to come back to in Linda's comments. Going to Ron's letter, there was a portion about Davido that I also thought spoke to me, where it said, Davido was the kind of person who helped everyone he met. In all the years I knew him, and remember, Mr. Rowland had known Davido for 45 years. In all the years I knew him, he wrote, I never knew him to have an enemy. He cared about people and went out of his way to help them. In fact, he talked about how Davido considered Mr. Burke a friend. And then we have sort of the impact that crimes like this have. The fact that people are going to miss Karen and Davido. And we got to hear today in court two really, I thought, powerful statements about just how much that loss is always going to be there. And the things that they know that Karen and Davido wanted to take part in and that their family wanted them to be able to share, and they can't now. And those were beautiful thoughts that you shared. And again, really important. Ron had talked, and everyone has talked about varying degrees about faith, about what the consequence should be, about people's feeling that they're not safe because these crimes hit at what makes people feel safe in our community. And those are really hard topics. I thought Ms. Dunn did a nice job of talking about it. A lot of people don't want to talk about these things. And I just wanted to take the opportunity to say we have two exceptional people in Karen and Davido who live their life in a way that they wanted to give to others. They wanted to be a light in the community. And those are things that should be an example for everybody. One of the things I've been so impressed with the family is that it has been clear since the very first court hearing that they wanted this process to be a fair process. They wanted a fair court process. They wanted Mr. Burke to be treated with all the protections that the law provides. And I think, again, that says a lot because when people are grieving and they've suffered such significant loss, it is normal and acceptable to have anger, and anger is an okay thing, and hurt. But my sense always was they wanted everything to be done the right way. And it was important to them to be able to be present and to see what happened and to be here and to make sure that the process was fair. And again, I think that says a lot for their mindset. And I will say, I think that also is a reflection of what Karen and Davido, it sounds like, would have wanted too, was that this would be fair. And this has been a fair court process. I've reflected and I've told people this. I thought both trial teams, they are attorneys that I know, and they are attorneys that are dedicated and they care. And the reason the trial got continued was there are many reasons, and I can't answer to all of them, but it was again to make sure that when we got to this point, both sides had a fair opportunity to present their respective theories of the case. And that's what happened. And I know a lot of people are here for the whole trial, and I know portions of the trial probably felt very long, but again, it was to make sure that this process was fair and both sides had an opportunity to present their theories. The jury took all that in, and the jury, in my view, and I commented on this in open court too, they took their duty and their oath as a jury incredibly seriously. And it was clear to me every day, and I think for all the people that were here in court every day, and a lot of you were, you saw that they came into court and it was a serious thing to each and every one of them. They deliberated and they delivered their verdicts. There is so much evidence in this case that supports the verdicts of the jury. And so today we're here for a sentencing, and that sentencing, both sides really are in agreement, but I want to just highlight a couple things. The legislature has given the courts 7 goals of really things to think about for sentencing. And of course, the law, we have court cases and court decisions and precedent, but these are the 7. 1, ensure that the punishment for a criminal offense is proportionate to the seriousness of the offense and the offender's criminal history. 2, promote respect for the law by providing punishment which is just. 3, be commensurate with the punishment imposed on others committing similar offenses. 4, protect the public. 5, offer the offender an opportunity to improve himself or herself. 6, make frugal use of the state's resources and local government's resources. And 7, reduce the risk of reoffending by offenders in the community. This particular series of events that occurred are the most serious offenses we have in the state of Washington. Mr. Thunheim touched on this, but the state included as Appendix A in their original sentencing memorandum the legislature's classification of these offenses: aggravated murder in the first degree. It's aggravated murder in the first degree based upon the way that terminology is defined in RCW 1095-020, which is a definitional statute, and then 10.95.030 is the sentences for aggravated first degree murder. The legislature has scaled all of the offenses between levels 1 through 15, except for aggravated murder in the first degree, which is a level 16 offense. The mandatory sentence is life without the possibility of parole, and that's exactly what the court's going to impose on Mr. Burke. They will be consecutive sentences, count 1 and count 3. I'm trying to explain just so if people have questions. Count 2 and count 4 were lesser degrees of murder that gave the jury basically options in terms of what findings they would make. The jury found proof beyond a reasonable doubt for all counts. But because count 1 and count 3 are the aggravated murder in the first degree, they control, and counts 2 and 4 are less important because those are lesser degrees of murder. And so That's why everyone was focused on count 1 and 3. But count 1 and 3 will be life without the possibility of parole. Those will be consecutive sentences. I appreciated Mr. Thunheim being thoughtful about community custody. Community custody in this circumstance seems unnecessary because it's a life sentence without the possibility of parole, and that is the court sentence. But I appreciate the carefulness of saying it should be included because by statute, it is something that, because of the serious nature of murder, that will be ordered as well. When the court, and I just want to address the defense objection, I appreciated Ms. Norden's briefing and her oral argument. I appreciate that defense is making this objection, but also the acknowledgement that the law does not support the request, which is why defense wants to raise the objection. But the law is clear. I want to go a step further, though. When the court looks at the goals that I read into the record, these goals of what a sentencing should be, in this case, this is the most serious case that the court has. And this sentence of life without the possibility of parole is the just, appropriate sentence when the court goes through and considers all of those factors, when the court had the ability to listen to the same evidence the jury did and to consider this case in the light of my going on close to 30 years experience in the court process. This is an appropriate and just sentence in this case, and the court will order it. The court is also ordering the restitution that'll be reserved in terms of the amount, but the court's ordering restitution. That means that within 6 months of today, a sentencing amount has to be submitted. Defense will have an opportunity to review that, to make any pleadings they want for the court to address. But if the state wants to pursue restitution, it just has to make sure the court has the ability to rule on that within the next 180 days. The court is ordering no contact with Karen and Davido's family. The court is ordering no contact with all of the individuals that testified at trial, with the exception of Mr. Burke's daughter. It might be, and we heard testimony from her, that there have been orders that she has obtained throughout their history, but that's not really part of this case. And the court's not ordering any no contact between Mr. Burke and his daughter as a condition of the sentence in this case. The court's also not ordering anything that would prevent Mr. Burke from speaking with the defense expert in this case. The court is urging Mr. Burke to get involved in every bit of social programming that you can get involved in at the Department of Corrections, everything that's positive. You know, one of the things the court heard, and you might be aware, is that there used to be a death penalty in the state of Washington that stopped. So you have a gift that Karen and Davido do not have. You have a gift of life. And so what I strongly encourage you to do is to get involved in everything you can that is positive, to try to undo, even if it can only be in a small amount, undo the huge harm that you've caused and the huge hole that you've caused in this community based upon your actions. The court is ordering that Mr. Burke will comply with all conditions imposed by the Department of Corrections, that of course he'll maintain law-abiding behavior, that he will engage in all positive social programming, including mental health treatment, while he's at the Department of Corrections. I'm really sorry that everyone is here under these circumstances. The courts obviously are limited. I can't undo the harm that was done. But my experience has been that sometimes having a sentencing, having an opportunity to have at least legal closure to a case can bring some peace. And I hope that having this opportunity and the opportunity to be through this process and see it to conclusion and to hear what the sentence is does bring some peace and allows grieving to continue, which I know will continue for a long time, probably forever in some ways. But what I would ask all of you is, and I think you all did a really nice job of expressing this either in court or in the letters, is using Karen and Davido as an example into thinking about how they would want you to move forward and what things they would want you to do. It's clear they would want you to live life to its fullest. They would not want the horrible nature of this crime to impact your faith in humanity, to impact your faith in others. And so I would just encourage you that they sound, and I wish I had had the opportunity to know them, but I've gotten to know them a little bit through all of you. And I feel the richer for even that. And so I encourage you all to continue to think about them and use them as an example moving forward. Mr. Thunheim, do you have any questions or clarifications about the court's ruling in the case?
No, Your Honor, thank you.
You're welcome. Ms. Norton, do you have any questions or clarifications from the court regarding the court's ruling in the case?
No, thank you.
Okay. One of the things, Mr. Burke, is there is a right to an appeal. That's something that you have to do within 30 days of today's date or you lose that right. So one of the documents Ms. Norton's going to go over with you is a document that goes over all your rights regarding appeal and post any sort of attack on the conviction or the sentence. And Ms. Norton will go over that with you. I want to make sure you understand that if you want to file a notice, you have to follow those timelines explicitly. And so if you have any questions of that after your attorney goes over it with you, let me know. She would not be your trial attorney, nor would Mr. Cabrera. But if that's something you want to do, they can help you with the paperwork to file your notice. Ms. Norton, did you have something you wanted to add?
Your Honor, I was just going to let the court know that certainly Mr. Burke's right to appeal is something that counsel has discussed with him. In anticipation of him exercising that right, I've handed forward a motion and proposed order that would address the appointment of appellate counsel, which of course is a right that Mr. Burke has.
The court has signed the order of indigency based upon the motion. I've signed that. I'd like to give you, Ms. Norton, some time to go over paperwork with Mr. Burke. I thought it might be best if I stepped off the bench to give you that time. Can you just let the clerk know when you're ready and I'll come back up?
Yes, Your Honor, thank you.
Okay. For everyone that's present here physically in court or on Zoom, I thank you for being here. You don't have to stick around if you don't want to. If you want to, you're welcome to. But what will happen now, like I explained earlier, is that they'll go over the paperwork. There's going to be fingerprints applied to the paperwork. When Ms. Norton's had enough time to go over that with Mr. Burke, she's going to let the clerk know I'll come back up. I then check in with both sides to see if there's anything that is in disagreement about the judgment and sentence, because that's the operational document. If there isn't, I'll review it. If I agree that it's consistent with my ruling, I'll sign it. If there is an argument about something, I'll hear that. But procedurally, that's all that will happen at this point. And so I always leave it to people. I'd rather give you the information and then you can decide what you want to do with that information. But if you choose to leave, I just, again, want to appreciate, I want to express my appreciation for all of you that all throughout this trial, you've been very respectful of the court and you've been very respectful of this process. And I appreciate that. Mr. Thunheim, anything else before the court steps off the bench to give defense counsel that time?
Oh, Your Honor, thank you.
All right. Ms. Norton, anything else from you?
No, Your Honor, thank you.
Court will be in recess until you're ready for me. Thank you.